And then we continue to Adam Morawski, who is a Polish multilingual lawyer with international background. In 2006, he founded his law firm, Morawski Partners, and ever since has acted both as a promoter of foreign investments into Poland and as an advisor for domestic and international business expanding worldwide. Adam has assisted large international corporate businesses as well as SMEs and high net worth individuals. He provides strategic advice, works mainly with board directors or acting as lead counsel for international projects. And in 2018, he kept under his umbrella a legal team of 54 jurisdictions. This is really impressive, coordinating a fintech project. Well, Adam, the stage is yours.
Thank you, Urs. Hello, everyone. I want to start with a question. Who has heard the term a COVID discount? How about that? That's a term that I've heard a lot recently, and it is actually quite hilarious. But the reality is much more serious. People start to ask that question, treating COVID-19 as an excuse not to perform their existing contracts. It is true that many businesses have faced real difficulties with performing their contracts, but how can one assess this, whether this is actually true? This is not always so simple. So it's very important to realize that COVID-19 is often treated as a reason to start renegotiating one's contract. And to illustrate how it works, let me quote an interesting experiment from Harvard University, which is pretty old. It dates back to the 1970s. In that experiment, one research assistant joined a queue waiting to use a photocopier, and they were trying to join to skip the line, simply asking a question. I have 5 copies to make. May I use the photocopier first? And believe it or not, about 60% of people would let them in, simply because I guess they were kind student folk and not very much in a hurry, unlike in business situations. But guess what? When the research assistant started asking a different question, simply saying, "Excuse me, I've got 5 pages, and may I use the photocopier because I'm in a rush?" And in another scenario, she was saying, "May I use the photocopier because I want to make copies?" So what difference does that make? What new information do you have here? Believe it or not, as much as 94% of respondents were actually letting that person in. And the simple reason is, it's a fact proved by psychologists, also working in business, that when people face a reason, they much easier accept a proposal. Robert Cialdini phrased it to the effect that people like to have reasons for what they do. Now, this is exactly what happens with COVID-19. People often quote this as a reason to start negotiating their contract or renegotiating their contract. So what do you do when someone approaches you with such a request to change the terms of your contract because they see COVID-19 as a force majeure event, and they make new demands. They want to change the terms that have been made. Well, you have only two options. You can either talk to them and renegotiate the contract, or you can not talk and engage in litigation. These are the only two options that you have on the table. And no matter if you start negotiating or if you want to think about litigation, these are the options that you can practically make. You can discuss being relieved from certain obligations, and I emphasize certain obligations, not all obligations, thus terminating the contract. But you can simply ask to cancel your rent for March and April, or you can say that a certain delivery of products that was planned for spring no longer interests you, and you would like to cancel that part of shipment. But on the other hand, you may be interested in continuing the contract. So you're only talking about being relieved from certain part of obligations. And it works both ways. You can discuss this when someone approaches you and wants to terminate your contract, and then you can discuss not terminating it altogether, but simply talk about being relieved from part of the obligations, or you can approach your own business partner and ask the same. In some cases, you may want to talk about termination of the contract. Termination, of course, is the most radical step. For example, if you have signed a preliminary SPA and wanted to purchase a company, and the only thing was to meet for a closing and sign the final agreement, and then the other party tells you that they're no longer interested in that closing, then here we go. Houston, we have a problem. And so termination is really the most radical solution, and not always interesting for both parties. So again, it's sometimes worth discussing this. Now, there are situations in which you can suspend the performance of your contract. I mentioned being relieved from rent for a period of time, and this is how you can phrase this in legal terms, that you can suspend the performance of certain contracts, and for a couple of months, the landlord will not be charging the rent, but on the other hand, the tenant will not be using the premises. That's the point. So in this aspect, it is different from being relieved from certain obligations. Here we're talking about suspending the performance of the entire contract, and that means that neither party has a right to exercise their parts of the rights resulting from the contract. So this could be an interesting solution for the time of the pandemic. Then finally, probably the most difficult way of approaching the contracts, because someone wants to change the current situation, is to change the actual terms. Now, this really sounds like discussing about the contract from the beginning. So this is really the most challenging way in most situations of approaching your contract. Now, let me now explain how it works from the legal point of view. And I would like to focus on international contracts because in most situations when people have their standard contracts, they have someone at hand who help them to move around their national reality. But how about international relationships, which are generally much more complex and much more difficult to understand? So you might ask if there is actually an international standard in contract law, which concerns the applications of force majeure. Well, here is one example of a solution that uses the mechanisms of force majeure, but this is not an actual law. It is interesting because this particular text was adopted by an international institution, an intergovernmental institution that proposes this as a standard in international relationships. But the problem is these mechanisms would need to be adopted into national laws or into some specific contracts. Much more interesting is an example of this United Nations Convention, which is an actual law. This is a convention which was adopted in most European countries, except for the UK, of course. The English have to be different, but most European countries have adopted this convention, and also it's been adopted widely internationally. What this convention, the problem with this particular convention is it's limited to contracts of sale of goods. So it would not apply to contracts for services. It would not apply to contracts concerning the purchase of businesses or real property. So it's got a pretty limited scope. That's why I also cared to show this previous text, because in practical situations, you have to make sure that someone relies on a particular law, or if someone relies on a particular model that was inserted into a contract. That's a substantial difference. And so before you start looking at this convention, you have to make sure that it actually is applicable. So, for example, in situations of a contract made between a French company and a German company, this convention makes part of the national law because both Germany and France have ratified this contract. If that contract concerns the sale of goods, then again, it does apply. Of course, there can be much more nuanced situations, so you have to be really careful about this. What mechanisms are used by both the UN Convention and the UNIDROIT text? They rely on a very simple assumption. The party that invokes COVID-19 as a force majeure event, they have to prove that this particular this is the actual reason because of which they fail to perform their part of the contract. And as I said, it is not always easy to check, but it is worthwhile reviewing this reason very carefully, because you should not take it at face value what the other party says. It is the obligation of the party relying on force majeure to actually prove that because of, in this case, COVID-19, they are unable to perform their contracts. And one interesting element which is connected with this mechanism is a notice. The party that wants to rely on a force majeure event needs to deliver notice of the occurrence of this event, and it is a formal act which needs to be performed. If the other party does not give notice of the force majeure event, then they cannot rely on it, and in any case they would be liable for damages, even if the contract is terminated because of the force majeure event. They would be liable for damages. Now let's look at the national standards in contract law. One very basic observation is that this situation looks very differently under common law and under civil law jurisdictions. In common law, the general approach is that if you have a force majeure clause inserted into your contract, then you can rely on force majeure. If you don't have the clause inserted in your contract, then forget about it. There are solutions elaborated in precedent law concerning the frustration of purpose and in practicability of performance of contract. These are doctrines used in common law, but let me simply tell you that they are extremely difficult to rely on in practice. So it really boils down to this. If you have a force majeure clause in your contract, then you can rely on it. If not, then you can't. And the UN convention that I mentioned earlier could help in some way in case, for example, if a contract is made between a US company and a German company, and US law would be applicable, but US is a party to Vienna Convention. So even though it is a common law jurisdiction, the Vienna Convention makes part of is part of the US law. And that's why in contracts for international sale of goods, this convention can be used. In other cases, you would have to go and find the relevant solution under US law. In civil law jurisdictions, these things are treated differently. Most civil law jurisdictions, they have mechanisms in their codifications that use the concept which is differently named. Sometimes it's called force majeure, sometimes it has other terms. In German, it's called Anweglichkeit. In Italian, there are concepts of eccessiva onerosità sopravvenuta, etc., etc. Let's take a look at a couple of examples. I am not going to discuss these particular mechanisms. Let me just tell you that in France, in Germany, in Italy, there are definitions of force majeure events, and there are provisions explaining how these mechanisms work. What is interesting about Italy is that they have a system of these certificates issued by local chambers of commerce. The chambers of commerce in Italy, they serve as the holders of company registers. In each province, they have a chamber of commerce that is responsible for confirming the occurrence of force majeure. And if a company has an international contract and wants to serve a notice to their counterpart, they can rely on these certificates. Here is an example of a certificate released by a Milan Chamber of Commerce. If you go east, in Russia, in Ukraine, in Poland, there are very similar solutions. Each jurisdiction there has provisions concerning the occurrence of force majeure, and both Russia and Ukraine have the system of certificates. So if a company wants to rely on a force majeure occurrence, they have to make an application. Here are examples of applications filed with the Moscow Chamber of Commerce on the left-hand side, and on the right-hand side you have an application used in Ukraine. Now, let's talk about something a little different. Let's talk about various mechanisms of aid offered by governments. This is, of course, not part of my presentation, not the main part of my presentation here, but let me point at it for just one reason. Many companies that will tell you that they want to change the terms of the contract because they have trouble because of this new reality. As I said, you should not take their statements at face value. Very often, they, at the same time, they're experiencing some real difficulties. They would be using some government funding, which would help them survive the current crisis, and they would not necessarily be in such dire straits as they might be saying. So before you. This is one way of verifying what the other party is saying. Simply ask them if they are using some public aid, which is offered by governments in this time. And finally, let me come back to my initial question. If, as I said, you have two solutions only. If someone wants to change the terms of a contract that has already been signed, or if you want to change that contract, you can talk with your business partner, or you can not talk to them. You may simply go to court. And how to reach that decision? Well, think about practicalities. If you cannot physically meet your business partner, use your local advisors. Even if you're based in Singapore, in Australia, in the US, and you cannot travel to Europe, use your local advisor in the country where your business partner is based, and that local advisor can physically go and meet them. And this is a major advantage of using your professional advisors in the times of crisis, when the freedom of movement is restricted. Finally, think about the costs. If you want to stick strictly to your contract, remember the cost of enforcing that contract may be pretty high in terms of legal fees, in terms of time, in terms of energy that is dedicated to the entire process of first trying to negotiate and then ending up in court and losing the contract. So there are reasons to seriously think about what to do before you make a decision. Yes, I will negotiate, or no, I will not negotiate. I will rather go to court. This is what roughly I wanted to cover for now. So thank you for my presentation. And before I go, let me make a very simple summary. My first point is that COVID-19 often works as a force majeure, but it doesn't work in all cases. The second point is invoking COVID-19 as a force majeure event in practical terms should be treated as an invitation to negotiate. The third point is you are not left without legal tools, but those tools are often complex, and it will be time-consuming to implement them. And my final fourth point is be active in your negotiations. Use your advisors who are available on the ground. And on this opportunity, I want to thank all the Bosco team and the wonderful panelists. This is the actual place where you can look for your advisors and your professionals to help you in this kind of situation. Thank you.